Welcome back. The Supreme Court today grilled petitioners seeking deletion of the words secular and socialist from the preamble of the Indian Constitution. The bench, led by Justice Sanjoy Khanna, asked the petitioners if they did not wish for India to be a secular country. The petitioners, who included Subramanian, Swamy and advocate Ashwini Upadhyay, argued that the terms were introduced during the emergency. The case will be heard again post the Diwali vacation, when Justice Khanna is likely to take over as the Chief Justice of India. To discuss this further, joining us now is senior advocate Sanjoy Ghose, as well as Bharat Chugh, advocate at the Supreme Court, as well as former judge. Gentlemen, thank you so much for joining us. Mr. Ghose, let me come to you. Very pointed questions being asked by Justice Khanna, soon to be CJI, where he asks, do you not want India to be secular? And as far as socialism is concerned, he went on to say that, look, we've had a fair bit of opportunities, a fair bit of opening up since the 1990 liberalization. Your thoughts on these observations falling from the next CJI?
Hi, thank you for having me here. Well, Mr. Subramanian Swamy is partially right that these amendments came during the emergency. It came through the dreaded 42nd amendment. But what the question Mr. Swamy has to answer is that when his Janata Party government came back to power, and after coming to power, when they brought the 44th Amendment, which did away with most of the 42nd Amendment, why did they leave that preamble amendment untouched of secularism and socialism? See, my point is this, that even the petitioners themselves are saying that you don't need such kind of amendments in the preamble to say that the Indian Constitution is socialist and secular, which it is. The point is the Supreme Court even entertaining such petitions when, for example, important issues like who controls Delhi, issues with regard to continued detention of political prisoners, issues like rights of labor, tribals, criminal appeals are pending. The Supreme Court hardly has time for them. And yet these kind of frivolous petitions are taken up and they get screen space. So that is an issue which is more important according to me, Ashmit.
Sure. Mr. Chugh, same question to you here, that is the Supreme Court giving oxygen to a petition that again is agitating a cause which they themselves, petitioners themselves, are saying that they're not against the secular nature of the Indian Constitution. They only have an issue with the preamble, the introduction of those two words. What are we achieving even by deletion of those words when the clear consensus does appear to be that it is the basic structure of our Constitution to be secular, to be socialist? Why agitate this issue at all?
Absolutely. Ashmit, this is more optics and political signaling and symbolism more than anything else. Now, this issue is long settled. Preamble is something that's an important part of the Constitution, and preamble is also something that can be amended by way of a constitutional amendment. And as Mr. Ghose rightly said, that it was amended in the 42nd Amendment, 1976, and these words were introduced. And that's been the position ever since. And there are various provisions in the Constitution which reflect the secular and the socialist ethos of our Constitution. Now, there are so many articles in the Constitution that prohibit a state from discriminating between citizens on the grounds of religion, which allow every citizen the right to practice and propagate and profess their religion, which basically draw a separation between the state and the individuals and religious matters. On this, and at the same time, on socialism, we have directive principles of state policy where the state is under a duty to ensure that there is no concentration of wealth, there is equal work for equal pay, and we ensure that every person gets his or her due. And if all of those provisions are there, and these are important aspects of the Constitution, they are a part of the basic structure of the Constitution, then their presence in the preamble, even otherwise, is something that is symbolic. So let's assume that you take these words out of the preamble, these provisions are going to remain, and no amendment can take them away. And any amendment that seeks to take them away, and for example, an amendment that seeks to take away the right of a person to practice their religion, is something that would be struck down as unconstitutional. Sure. And I completely agree with Mr. Ghose that the Supreme Court's time is better spent, discussing issues of personal liberty and far more pressing issues of constitutional reform.
Mr. Ghose, let me ask you then, when you raised the point that Janata Party came to power after the emergency, they had the opportunity to turn this around. They did not do so. Now this issue is being agitated in 2024. Is there perhaps a rationale? Can there a case be made that perhaps the petitioners are not really coming with clean hands, that they may be chasing goals beyond what is stated on record, using the Supreme Court as a platform?
Well, very rarely you'll have panelists on a program like yours agreeing. But Bharat is a good friend, and we both seem to be saying the same thing, that of course, I mean, it is clear as daylight that this whole thing is a pulpit for optics. What turns on that? Let us say that, I personally feel that the preamble being the only dated part of the Constitution. I say dated because the preamble, unlike other parts of the Constitution, says adopted on this 26th day of November 1949. So I personally feel that the preamble being dated is a part of history and should not have been amended. But now the amendment is there. The amendments have been upheld in many cases, certain amendments. So these amendments have been relied upon by the Supreme Court in many cases to decide what is the basic structure of the Constitution. So according to me, this whole thing, this whole exercise is meaningless. At the end of the day, you simply say, I've removed the word secularism and removed the word socialism and, play on that. But the Constitution is what the Constitution says, and nothing can change the ethos of the Constitution. In fact, as Bharat was saying, the Supreme Court, as you know, in Bommai's case and several other cases, has already said that secularism is a part of the basic structure of the Constitution. So therefore, even an amendment on removing that term secularism will achieve precious little.
Sure. Mr. Chugh, in the final moments of the hearing today, one remark fell from one of the petitioners saying that this matter, when it's heard next, will be heard in Court 1, given that Justice Khanna is due to be elevated. He's due to take charge of the CJI's office on November 11th. The question that I ask you is, the concern that you had raised, that there are far more important issues. This matter is due to come up in November, soon after he takes charge. Could this have been one issue that Justice Khanna, the new CJI, could have done without, given that he does have a brief term of just about 6 months?
Absolutely. And for one more reason, I mean, these are matters where essentially the legislature, as the representative of people, should take a call. Now, our Constitution is a flexible Constitution. It's a living document. It has provisions for amendment. And I said earlier, the provisions of amendment or the power of amendment includes the power to amend the preamble. So let these petitioners go back to the representatives of people, try and convince them, try to get consensus around the issue that, for example, for the sake of argument, that socialism is an economic model that does not serve us anymore or does not serve us as well and is incompatible with liberalization or the free market ethos that we now follow. Let them convince the representatives of the people. Let them come up with a constitutional amendment. Let that be discussed in the parliament and then it be tested in a court of law. Actually, this is something that invites the court to overreach, to be adventurous in its approach. And at the end of the day, a court decision on a matter like this also can be called or characterized as undemocratic, because at the end of the day, it's the representatives of the people who have to take a call. And that's where ultimately this decision should lie.
Let me take that across to Mr. Ghosh for one final comment. We're completely out of time, but I'll just come to you, Mr. Ghosh, for a final comment. In the case of the petition seeking same-sex marriage rights, the Supreme Court at that time, the landmark verdict that came is that this is an issue best left to the Parliament, to the wisdom of the legislature. If issue of same-sex marriage rights is to be decided by the Parliament, the secular and the socialist nature of the entire country of the Indian Constitution, is that not an issue that perhaps is the best preserve of the Parliament, where it's debated, discussed between all the experts as well as the representatives?
Look, I am not a subscriber of the theory that the Supreme Court can't go into everything and should leave it to Parliament. The Supreme Court's role is to be the custodian of the Constitution. So if there is an amendment to the Constitution which is offensive to the core of the Constitution, to the basic structure of the Constitution, the Supreme Court, as the sentinel to protect the Constitution, certainly will do. And therefore, you can't have a general principle that the court should not get into it. But certainly in a case like this, there is no threat to the Constitution. It could be surplusage, it could be extra words. And therefore, I would say that in the same-sex case, in fact, the Supreme Court should have interfered. And it did not interfere. This is a case where the Supreme Court should not interfere. And I hope they don't interfere.
Sure. Well, in fact, the review petitions in the same-sex marriage case are still pending. CJI has about, including today, 10 more working days. So we have to, of course, wait and watch what the decision may come, if it comes at all, during the tenure of CJI Justice Chandrachud. I'd like to thank all of our panelists, Mr. Ghosh, Mr. Chugh, for joining us and sharing the benefit of your insight for our viewers. But with that, it's a wrap on this edition of News Center. More news and updates will continue right here.